All right.
Against JFS.
Yes, Lord Pennick.
Good morning, my lords and my lady. I appear with Peter Oldham and Professor Christopher McCrudden for JFS. Ben Jaffe appears for the United Synagogue. Thomas Linden and Dan Squires for the Secretary of State. David Wolfson, Sam Brzezinski and Professor Eileen McColgan for the Board of Deputies. Dinah Rose and Helen Mountfield for E. Robin Allen and Will Dobson for the Commission, and David Wolfe and Adam Sandel for the British Humanist Association. The court will have seen that JFS is a very successful, comprehensive secondary school which is maintained by the local education authority, the London Borough of Brent. And it receives every year substantially more applications than there are places. This appeal concerns whether, as the Court of Appeal found, and as we dispute, it amounts to direct or indirect race discrimination contrary to the Race Relations Act 1976 for this Jewish faith school to adopt oversubscription criteria which give priority to children who are recognised by the Chief Rabbi to be Jewish according to Orthodox Jewish religious principles. And E's son, M, fell outside those oversubscription criteria because M's mother converted to Judaism in a non-orthodox procedure which is not recognised by the Chief Rabbi. Our case is that the refusal of the place to M was not an act of race discrimination, that is, less favourable treatment on the ground of ethnic origins. We say, and I will develop the submission and respond to the printed case for E, we say that M failed to secure a place at the school because, and only because, of the religious criteria applied by the Chief Rabbi as to who is a Jew. And those religious criteria, we will submit, do not depend on a person's ethnicity. As to indirect discrimination, we will submit that the criteria adopted are legitimate and they are proportionate. We will say that a faith school is entitled to adopt an oversubscription policy that gives priority to those children who are members of the relevant faith as defined by the religious authority of that faith. These are clearly important issues, Perhaps of somewhat lesser importance, there is also an appeal by the United Synagogue in relation to the costs order imposed by the Court of Appeal, on which we, JFS, take no position. My Lords and my Lady, I hope the Court has had an opportunity to read the background documents and the statutory provisions which are relevant to these issues of law. Would it assist, I hope it assists, if I very briefly identify the core background materials before I make and develop my submissions and I respond to the printed case on behalf of E. The Court will have seen that the starting point is the 2002 Education Act, which is at volume 8 of the materials. I invite the Court, please, just to glance in volume 8 at page 17, the numbering at the top of the page, volume 8, page 17, where the Court will find section 21 of the Education Act 2002. And section 21, subsection 4, refers to the governing body of a maintained school, and it tells us that the governing body shall, in discharging their functions, comply with the instrument of government. So the instrument of government is the fundamental document. And the instrument of government in this case can be found at Appendix Part 2, page 716. Appendix Part 2, page 716, Instrument of Government for JFS. And your Lordships and your Ladyships see at paragraph 4 the composition of the governing body. There are 4 parent governors, there's 1 local authority governor, there are 4 staff governors, but the majority are foundation governors, 11 of them, and I'll come back to them in a moment. The total number of governors is 20. At 7, the foundation body, which appoints, of course, the foundation governors, is the United Synagogue, whose school's foundation committee shall appoint all foundation governors. The honorary officers of the United Synagogue are the trustees. And then 8, statement of school ethos, recognising its historic foundation, JFS will preserve and develop its religious character in accordance with the principles of Orthodox, I emphasise the word, Judaism, under the guidance of the Chief Rabbi. The school aims to serve its community by providing education of the highest quality. Within the context of Jewish belief and practice, it encourages the understanding of the meaning of the significance of faith and promotes Jewish values for the experience of all its pupils. And 9, 10 and 11 add nothing of relevance. The role of the foundation governors is addressed in regulations, which the Court will find in volume 12 of the materials at tab number 83. And at tab number 83, the Court will find the School Governance Constitution England regulations, and at regulation number 8, the Court will see that foundation governors are addressed, and foundation governor is defined to mean a person who is appointed as a governor otherwise than by the LEA, and who is appointed for the purposes of securing that the character of the school, including where the school has a particular religious character, such religious character is preserved and developed. So the foundation governors, the majority of the governors, have a particular role for preserving and promoting the character of the school, including its religious character. Now, the 1998 Act, which the court will find at volume 10, deals with admissions to a school, and it provides that the admission arrangements for a school are to be carried out by an admission authority. And the relevant provision is section 88, which is on page 82. And the court will see at section 88 on page 82, the admission authority, 88.1, B, in relation to a voluntary aided school, which JFS is, means the governing body. So the governing body is the admissions authority for this school. And if the court would turn on to section 88C, which is on page 86, the court will see the procedure for determining admission arrangements is set out. The admission authority must, before the beginning of each school year, determine in accordance with this section the admission arrangements. Subsection 2, they must consult, and subsection 3, regulations may make provision specifying persons who must be consulted. And the Secretary of State has made regulations which require that the Chief Rabbi be consulted about the admissions arrangements. If the court would go to volume 12 at tab 82, the court will see the school admission arrangements regulations. The court will see regulation 1.3. These regulations apply for the academic year 2010 to 11 and subsequent years. There were earlier regulations to the same effect from November 2007. And if the court would turn on, please, to regulation 12, persons who must be consulted. 12.1, this regulation prescribes for section 88C2 the persons who must be consulted about proposed admissions arrangements. And at 12.2i, in the case of a foundation or voluntary school which is designated as having a religious character by an order under section 69.3, to which I'm coming, the body or person representing the religion or religious denomination in question. And sub-regulation 7, for the purposes of subparagraph 2i, the bodies or persons listed in the second column of the table must be consulted. And the table says Church of England, then it says Jewish, and the body or person to be consulted is the appropriate rabbinic authority for the school listed in Schedule 2. And Schedule 2 appears on page 22, and the court will see the second rabbinic authority down is the Chief Rabbi of the United Hebrew Congregations, and he is the appropriate authority for a number of schools, the fifth of which is JFS.
So are the schools that are listed under reference to him, have you taken those of the Orthodox
Yes,
branch of the
precisely.
Jewish religion?
Precisely. Yes, some of the others are Orthodox, but they don't necessarily recognise the Chief Rabbi. They recognise other rabbinic authorities.
Well, it's spread amongst the various,
Yes,
the various aspects of the Jewish religion.
it is. But what the court will see is JFS is recognised for the purposes of these regulations as within the religious authority of the Chief Rabbi. Now, the governing body of JFS has adopted an admissions policy which has set out an oversubscription criterion. And the admissions policy for entry in September 2007, which is when M wished to enter the school, is at Appendix Part 2, page 729. And the admissions policy is set out at page 729 of Appendix Part 2, at paragraph 1.1. It is JFS policy to admit up to the standard admissions number children who are recognised as being Jewish by the office of the Chief Rabbi of the United Hebrew Congregations of the Commonwealth, the OCR, or who have already enrolled upon or who have undertaken with the consent of their parents to follow any course of conversion to Judaism under the approval of OCR. In the event that the school is oversubscribed, then only children who satisfy the provisions of paragraph 1.1 above will be considered for admission in accordance with the oversubscription criteria set out in section 2 below. And section 2 below sets out priorities within the category of children who fall within 1.1. And there's no dispute at all material times JFS has been oversubscribed. There are also statutory provisions governing faith schools. If the court would go back, please, to the 1998 Act, which is volume 10, and if the court will look, please, at page 62 in volume 10, numbering at the top of the page, page 62. The court will see section 69, which is concerned with due provision of religious education, 69.3. For the purposes of this part, a foundation or voluntary school, JFS is a voluntary school, has a religious character if it is designated as a school having such a character by an order made by the Secretary of State. An order under subsection 3 shall state, in relation to each school designated by the order, the religion or religious denomination in accordance with whose tenets religious education is or may be required to be provided at the school in accordance with Schedule 19, or as the case may be, each such religion or religious denomination. And JFS has been designated by the Secretary of State pursuant to those powers. The designation order is at volume 11 of the materials, and it's tab 77.
So
Which volume was it?
Volume 11, my lord. Tab number 77. There's a long list, and the court will find the relevant entry at page 35. And if the court has page 35, the court will see halfway down page 35, under the heading Camden, there's a reference to the Jews' free school, and the designation is Jewish. It's under the heading Camden because, of course, the school moved from Camden Town to Kenton in northwest London in 2002. It was at that time in the London borough of Camden. Now, one of the points that is made in the printed case for E is to point out that more recently some independent schools have been designated by the Secretary of State as Orthodox Jewish. The court sees that the designation there is Jewish. That point failed before Mr. Justice Mumby for reasons that he set out in detail at paragraphs 216 to 227 of his judgment. And the Court of Appeal was also unimpressed with this point when it was made by Ms. Rose. Court of Appeal judgment, paragraph 24. And the reason the Court of Appeal and Mr. Justice Mumby were unimpressed is because whether a school is an Orthodox Jewish school depends on its instrument of government, and the policy of the Secretary of State at the time, and there's a great deal of evidence on this, was not to distinguish for designation purposes between Jewish and Orthodox Jewish. But I wasn't proposing to go into this at this stage. I rely on Mr. Justice Mumby's judgment, and I rely on the Court of Appeal being unimpressed at paragraph 24 of this point.
I didn't understand that the point was being run before us.
So be it. Ms. Rose will make her position clear in due course, I'm sure.
Well, the position is... The position is that this is one of the issues that was adjourned by the Court of Appeal and hasn't been resolved.
Very well. Well, I'm very grateful to your Lordship and to my friend in relation to that. The Court will also wish to look at the Equality Act of 2006, which appears in volume 9 of the materials at tab 71. And I invite the Court to open tab 71 at page 33. And page 33 is the beginning of part 2 of the Equality Act, which addresses discrimination on grounds of religion or belief. Section 44, tab 71 of bundle 9, my Lord.
Thank you, and page again.
Bundle 9, my Lord, tab 71.
Yes.
At page 33.
Yes.
That is the beginning of part 2, which addresses discrimination on grounds of religion or belief, Parliament having introduced for the first time in England and Wales, the obligation not to discriminate on grounds of religion or belief. Section 44, religion and belief, is defined. Religion means any religion, belief means any religious or philosophical belief. Reference to religion includes a reference to a lack of religion and similarly a lack of belief. 45 defines discrimination. 45(1) is direct discrimination. A person discriminates against another for purposes of this part if on grounds of the religion or belief of B or of any other person except A, whether or not it's also A's religion or belief, A treats B less favourably than he treats or would treat others in cases where there is no material difference in the relevant circumstances. 45(2) clarifies this concept. A reference to a person's religion or belief includes a reference to a religion or belief to which he is thought to belong or subscribe. So it's not confined simply to what a person happens to believe or happens to practice. Subsection 3 is concerned with indirect discrimination. I won't read that out.
Can you belong to a belief, or does belong simply apply to religion?
I think subscribe governs belief, doesn't it?
Yes.
Subscribe to belief and belong to a religion.
I would respectfully agree with my Lord Lucas. Subsection 4 deals with victimisation provisions, and we don't need to take time on that. Section 49 deals specifically with education. The court will appreciate that such discrimination is made unlawful in particular context. 46 is goods, facilities and services, 47 is premises, and 49, educational establishments. 49(1), it is unlawful for the responsible body, and we see who the responsible body is from the table at the top of page 37, and in a school maintained by the LEA, it's the LEA or the governing body. So it's unlawful for the responsible body listed in the table to discriminate against a person in the terms on which it offers to admit him as a pupil, by refusing to accept an application for admission, or in various other ways. But Section 50 sets out exceptions, in particular 50 subsection 1, Section 49(1)(a) and (b), with which we are concerned, shall not apply in relation to a school designated under Section 69(3), as the court has seen, JFS is such a school. So to the extent that the complaint were that a potential pupil has been refused admission to JFS on the basis of religious discrimination, there would be a complete answer to that complaint. The court will also wish to be aware of the code for school admissions published by the Secretary of State. This code is made pursuant to powers conferred by Section 84 of the 1998 Act, which was the one in Volume 10, but I don't invite the court to turn that up. That's the statutory origin. The code itself, there are three versions of the code, 2003, 2007, and 2009. Nothing turns on the distinctions, and I'm going to invite the court, please, to look at the one for 2007, which is at volume 12 of the materials, at tab number 85. This addresses the question of faith-based over-subscription criteria. And I invite the court please to turn to page 54 of this code, published by the Secretary of State. Page 54 is headed Additional Guidelines for Faith Schools. Paragraph 241 on page 54. The Secretary of State tells us it is unlawful under section 49 of the Equality Act, as the court has just seen, for maintained, non-maintained or independent schools to discriminate against a child on the grounds of the child's religion or belief in the terms on which it offers to admit him as a pupil or by refusing to accept an application for a place at the school. However, those schools, this is section 50, those schools designated by the Secretary of State as having a religious character, that's faith schools, are exempt. They are permitted to use faith-based oversubscription criteria in order to give higher priority in admissions to children who are members of or who practice their faith or denomination. This only applies if a school is oversubscribed. 242. Faith-based oversubscription criteria must be framed so as not to conflict with other legislation, such as equalities and race relations legislation, or the mandatory provisions of this code. As with all other maintained schools, faith schools are required to offer every child who applies, whether of their faith, another faith or no faith, a place at the school if there are places available. In other words, if it's not oversubscribed. As with all oversubscription criteria, those that are faith-based must be clear, objective and fair. Parents must easily be able to understand how the criteria will be satisfied. It is primarily for the relevant faith provider group or religious authority to decide how membership or practice is to be demonstrated. And accordingly, in determining faith-based oversubscription criteria, admission authorities for faith schools should only use the methods and definitions agreed by their faith provider group or religious authority. It's good practice for the governing bodies of all faith schools that are their own admission authority are proposing to use faith-based oversubscription criteria to consult their religious authority before going out to statutory consultation with other admission authorities. And then 244 deals with Church of England schools. I don't think I need to read that. 245, the admission authorities of all faith schools are required to consult such body or persons representing their religion or religious denomination as may be prescribed in regulations. And the court saw that earlier. The Chief Rabbi is designated as the appropriate consultee.
Can I just pick up the word membership?
Yes.
Membership in the fourth line of 2.43, that is linked to what? Membership of?
Of the faith.
Of the faith.
Yes. The concept of membership appears 3 times in these paragraphs. It appears at paragraph 241 in the penultimate line. It appears, as my Lord indicates, at 243 in the 4th line. And it also appears, as the court will see in a moment, in 247 in the 5th line. And there is evidence from the Secretary of State that that is deliberate, and it is very much the policy of the Secretary of State that it should be appropriate for a faith school to define its oversubscription criteria by reference either to membership of the faith or practice of the faith. And both are legitimate, and I'll come to that when I come, if I may, to indirect discrimination. And I'm grateful membership also appears, there's a 4th mention at 246 in the 1st line of 246. Thank you.
Yes.
So 245 deals with consultation. In addition to consulting other admission authorities, such religious authorities may refer an objection to the adjudicator. 246, published admission arrangements must make clear how membership or practice is to be demonstrated in line with guidance issued by the faith provider group or religious authority. It must be objective and transparent. And 247, religious authorities may provide guidance for the admission authorities of schools of their faith that sets out what objective processes and criteria may be used to establish whether the child is a member, so membership again, of, or whether they practice the faith. The admission authorities of faith schools that propose to give priority on the basis of membership or practice of the faith should have regard to such guidance to the extent guidance is consistent with the mandatory provisions and guidelines of the Code. So very clear that the Secretary of State, for his part, accepts, recognises that it is perfectly proper to adopt oversubscription criteria by reference to membership of the faith. It is also correct to emphasise, as my friend Miss Rose does, that all of this guidance is on the basis that the school must, of course, comply both with equalities legislation and race relations legislation. That's 242 in the first and second lines. And none of that is in dispute. I emphasise, for the avoidance of any doubt, my case is not that we have some exemption from the Race Relations Act. My case is that, properly analysed, we are not in breach of the Race Relations Act.
Can I ask, was this the first occasion on which faith-based over-subscription criteria were so defined? There doesn't appear to be an equivalent in the 2003 Code.
Well, if your Lordship would go to tab 84, which is the 2003 Code, and your Lordship would look, please, at page 11, which deals with faith schools, your Lordship will see at paragraph 3.9 on page 11, schools designated by the department as having a religious character may give preference in their admission arrangements to members of a particular faith or denomination, provided this does not conflict with other legislation such as race relations legislation. So the same concept appeared in 2003. It is true that the Secretary of State decided, no doubt wisely, to provide more detail in the 2007 Code, but the same concept appeared in 2003. May I then turn, please, to the factual circumstances?
Sorry, Lord Planning, it's a bit early to ask it, perhaps, but do any other faiths besides Jewish faith, in fact, establish criteria by reference to membership rather than practice, which is the other limb of the Code?
There are certainly a number of Catholic schools that do not base their oversubscription criteria on practice. They base them on baptism, and the school will allow priority under oversubscription criteria to a child who was baptised, irrespective of whether the child or the parents practices Catholicism or indeed believes in Catholicism. The test for a number of schools, as I say, is a test of baptism. But I cannot suggest to your Lordship there's any other material that I'm aware of that refers to other schools basing their oversubscription criteria on membership in the way that Jewish schools do.
And baptism in the Catholic faith gives rise to membership of the Catholic faith, does it?
I'm not so suggesting, I'm simply distinguishing in answer to your Lordship's question between those schools which base oversubscription criteria on a test of religious practice contemporaneous religious practice or belief, but rather base the oversubscription criteria on an historic event which is not coextensive necessarily with practice or belief.
Well, I suppose an issue might arise as to whether that is discrimination on the ground of religion or on the ground of something which might have nothing to do with any forbidden basis of discrimination, like the colour of your hair.
Indeed.
The 2003 code, just reading on from the passage that you mentioned,
yes,
doesn't seem to anticipate the present concept of membership at all. It deals with how membership should be demonstrated, whether a statement of religious affiliation or commitment would suffice, whether it's to be tested, and if so, what references from the priest, minister, or other religious leader would be required. It just doesn't address the present.
No, I respectfully agree. It's in very rudimentary terms. It recognises a concept of membership as a permissible basis, but begs many questions as to what that means. And that's why the 2007 code, I would respectfully submit, is far more helpful in identifying what the policy of the Secretary of State is, what guidance is provided, which of course is not to say that the court is in any way bound by that, but I show the code as an indication of the ministerial policy in this area. My Lords, my Lady, may I then turn to the factual circumstances? As the court knows, M's mother was born a Catholic into an Italian family, and she was converted to Judaism by a non-Orthodox rabbi before she married E.
It's very interesting that you use that phraseology. She was born a Catholic. I don't know enough about Roman Catholic theology to know whether it's possible to be born a Catholic as opposed to baptised a Catholic.
Your Ladyship is entirely correct to pick me up on that. She was a Catholic, according to the material. At all material times, the Catholicity of her origins are what are referred to by the printed case on behalf of E. And I make no point, I was seeking to make no point.
No, perhaps I was.
Well, I understand. I certainly understand that Your Ladyship was. She was converted to Judaism. However, it is accurate to describe her previous position. She was converted to Judaism by a non-Orthodox rabbi before she married E. The parents, E and the mother, are now divorced. M lives principally with his father. E and his son M are members of a non-Orthodox synagogue, the Masorti Synagogue, and they both practice Judaism. And the court will wish to be aware of E, the father's witness statement, at Appendix Part 2, at page 500. This is the father's witness statement. At paragraph 5, on page 500, the father says, I am a practicing Jew. I'm a member of the conservative Masorti synagogues, that's the non-Orthodox synagogue, in other words, not under the auspices of the Chief Rabbi. Before I married M's mother, who is Italian, she converted from Catholicism to Judaism here in London at a synagogue under the auspices of the Reform Beth Din. In fact, that was corrected later. It was, in fact, a progressive synagogue, according to Mr. Justice Mumby, Appendix Part 1, page 38, although nothing turns on this. M himself is a practicing Jew. we attend synagogue on the high holy days, and the New London Synagogue as a family whenever possible. M has been a member of that synagogue since 1997, the year of his birth. He's very serious about, and he actively practices his faith. He attends a Jewish youth group each week. He says prayers in Hebrew and English at the meals we take together as a family. He's keen to begin Jewish and Hebrew studies. He reads Jewish phrases and jokes. He's worn a kippah, it's a head covering, outside the synagogue to his primary school, but he felt unable to continue due to unwelcome attention. And then in paragraph 7, at the top of page 501, M is recognised as Jewish by the Reform synagogues of Great Britain and the Reform Beth Din, and he's also recognised as such by the Assembly of Masorti synagogues, of which his own synagogue belongs. We also now have a witness statement from M himself. I hope the court received that. I have it loose. I hope the court has it. Can I simply invite the court's attention to two paragraphs which touch on this aspect of the case. Witness statement of M. His full name is given. And if your lordships and your ladyship please would turn to paragraph 3 of M's witness statement. The court will see that M describes how old he is, and then he says, for as long as he can remember, his Jewish faith has been part of who I am. So, for example, at home, I mark and celebrate the Sabbath with my dad. We take turns saying a prayer in Hebrew before every dinner at home. He's attended the Masorti synagogue almost every Saturday for years now. He celebrates all the high holy days there. He goes to Jewish study classes at the synagogue to learn about his faith and history on Sundays, and he's been involved in the youth movement, and he went to summer camp. That's paragraph 3. He adds to that at paragraph 12, also indicating his connection to his faith. At paragraph 12, he describes things at the school he was attending before beginning at JFS. He describes how at his primary school, the third line is referring to his primary school. At primary school, I had always been, he says, a bit of an odd one out because of my Jewish beliefs and values, and he could not wear his kippah, his head covering, because the one time he did, he was taunted. And he knew it was not going to be any different at the school he attended, the secondary school, before he joined JFS. So that's his evidence. Now, in April 2007...
So he's a member of a Jewish faith, is he?
He's a member of the Masorti Synagogue, which is not an Orthodox Jewish synagogue. It's not recognised by the Chief Rabbi.
But is it right to say he's a member of the synagogue or a member of something broader than that?
Well, he's certainly someone, and I will accept this, from the point of view of Mandler and Lee, he would say, with force, that his ethnic origins are Jewish.
Yes.
He would also say that his religious beliefs are Jewish, and whether he's a member of the synagogue, I'm not sure, given his young age. He may or may not be, but certainly his father is a member of the synagogue, and the court will proceed on the basis that once he's old enough, he will certainly become a member of his synagogue.
And that would be a member of a Jewish faith, or the Jewish faith, or what?
No, from the point of view of the Chief Rabbi, it would not be a Jewish faith.
It wouldn't be a Jewish faith?
It would not.
But only from the point of view of the Chief Rabbi. I mean, can you be a member of a Jewish faith without being approved by the
Chief Rabbi?
Well, he is a member of a religion which would describe itself, and many other people would recognise it to be Jewish. It's just different from Orthodox Judaism.
I mean, the ordinary man on the street might regard him as
Certainly.
a member of
I entirely accept
a
that.
Jewish faith, or possibly even the Jewish faith, if
I entirely
that member
accept
of the
I entirely
man on the
accept
street didn't know that there were several.
Yeah, I entirely accept that.
Would
Judaism, of course, is not unique.
No, I wasn't
Far
just
from it, in having schisms and divisions and disputes as to what is the true faith. And it is common, no doubt regrettable, but it's common, I apprehend, to all religions that there are divisions, disputes as to what is the true faith and what is not. But I entirely accept, there's no part of my case to dispute that M regards himself very much as Jewish, and that he would be regarded as Jewish by many, many people. His problem in this case is that he's not recognised as Jewish by the Chief Rabbi.
But is it your position, then, so far as religion is concerned, if we're properly within the branch of religion, it's for the Jewish faith to organise its own membership rules according to its own beliefs?
Very much
It may lead to divisions of opinion within the faith, but that's not a matter for the court to
With great respect,
to
yes,
police.
precisely so. Precisely so.
would the Chief Rabbi recognise him as Jewish in any sense? Does the Chief Rabbi recognise any form of Jewishness other than religious Jewishness?
Well, if you put the question to the... Of course, I don't represent the Chief Rabbi, but if you put the question to the Chief Rabbi, do you accept that applying the criteria in Mandler and Lee, that is the question, what are the ethnic origins of M for the purposes of the Race Relations Act, it would, in my submission, be very difficult indeed, almost impossible, for the Chief Rabbi to dispute that M's ethnic origins for the purposes of the Race Relations Act are Jewish. And that's for all the reasons I've just read out. M regards himself as Jewish, and as my Lord Clerk has put to me, M would be regarded by almost everybody as being Jewish. The people who don't regard him as Jewish are the Orthodox Jewish community, who apply a particular religious test.
But when you say Jewish, that needs to be more closely defined, doesn't it? I mean, they don't accept him as a member of
Yes.
the Jewish religion or religious faith.
Indeed.
But you've pretty well come close to this. They would concede, if driven to it, that ethnically he was a Jew.
Yes. I don't have to be driven to it with great respect, my Lord. It is fundamental to my case that there is a vital distinction between whether someone is Jewish according to Orthodox religious principles, which is the test applied by the oversubscription criteria, and the different question of whether someone is Jewish in the sense of their ethnic origins for the Race Relations Act or any other purpose. I'm not driven to recognise that distinction. It is vital and fundamental to the case that I'm advancing before this court.
And there are some Jewish schools which have a broader definition of being Jewish. And if he applied to one of these schools and was given preferential admission, you would say that that was preference on the ground of his religion.
Certainly.
Jewish religion.
Well, Ms. Rose says, not sotto voce, but rather
Yes.
loudly, there are no such schools. But as I understand it, my Lord is putting to me a question on the assumption
Yes.
that there would be such a school, as indeed there will be, starting, as I understand it, next September in northwest London. But if such a school exists and M were to
Yes.
apply to it, and that school's oversubscription criteria were not based on the rulings of the Chief Rabbi, but were rather more general, then certainly M would fall within it. And anyone who challenged preference for M would be met with the answer, you have no complaint in law, because this is well within Section 50 of the Equality Act 2006.
But the same school, if it in fact was Jewish according to the Masorti rabbinical rabbinical authority could very well, in fact, refuse a child because that child was only recognised by the liberal or progressive.
Yeah, it doesn't quite work like that because the majority will recognise anyone. They are more inclusivist, if I may put it that way. The Orthodox community has a smaller cohort. The majority will recognise as Jewish everyone within the Orthodox community and some more. And the liberals will recognise even more people. But I don't think there's anyone who would be recognised as Jewish for religious purposes by the majority who is not recognised also by the Chief Rabbi.
Could I ask you
Yeah,
a question to which I ought to have picked up the answer, but it's not clear from the statement of facts and issues. When the Chief Rabbi is considering, and therefore the school is considering, the situation of a child whose mother is ethnically Jewish, not Jewish by conversion, does the Chief Rabbi and or the school look into the precise version of Jewishness that the mother may or may not subscribe to?
Well, the Chief Rabbi is concerned only with whether or not, as a matter of religious law, the mother is or was Jewish. He's not concerned with any other question.
Yes, but what I'm getting at is if the mother was by descent a Masorti Jew rather than an Orthodox Jew, what would the attitude of the Chief Rabbi be in that situation? Would he accept that M was Jewish?
No.
Or would he not?
No. The fact of conversion is completely irrelevant. There is no difference in analysis depending on whether the mother was converted or she wasn't converted. The question is whether or not M can show that his mother is or was Jewish, and he is treated...
But by that you mean Orthodox Jewish? That's all I'm getting at.
Orthodox Jewish.
Yes,
right. Oh, yes, absolutely.
No, that's
Orthodox
all I wanted to know.
Yeah.
Is that's clear from the criteria, is it? I didn't pick that up.
No, it isn't at all clear, or from the statement of facts and issues.
No. I must put on the record that is completely incorrect. If the mother is of ethnic Jewish descent, her practice of the whole family is probably irrelevant. They may not subscribe to any form of Jewish law.
Yes. As I understand it, you trace the child up the female line, and ultimately, it may be a long way up the line, you will get to a woman who would be recognised as an Orthodox Jew, and that's enough. It doesn't matter how many there are in between who have not been practising any faith at all.
No, well, my Lord, except we take issue with the notion of practising as an Orthodox Jew.
There's no dispute between us. There's simply no dispute. I'm not contending that practice has anything to do with this. That is not my submission. I'm not suggesting that whether the mother practices or she doesn't practice. The only question is whether she is, or she has died, was, a Jew according to the criteria recognised by the Chief Rabbi, which will depend on whether her mother was an Orthodox Jew, and will depend on whether the grandmother was.
Ultimately, you must get home to a lady who has some claim to being Jewish, other than the fact that her mother was Jewish.
It will go back to Eve, no doubt that is so. But the way it works in practice, of course, is that one produces the marriage lines that show that the mother and the grandmother were married in an Orthodox synagogue, which demonstrates that at that time, which may be 50 or 100 years ago, the rabbinic authorities recognised by the Orthodox community were satisfied. So one doesn't need to prove back hundreds of years.
And presumably if you went back to a stage where there weren't these splits, then you would just assume that anybody who had been married at that time would be...
No doubt. Well, precisely so. But I entirely accept my friend's point. I'm not suggesting that practice, or indeed belief, has anything to do with this. That's certainly not my case.
Well, how far do you have to go back before there were any splits? No, but seriously, I mean, when was the first split?
Well, 19th century. Can we look at that? Because I don't immediately know the answer to that. don't know.
Splits, the big splits are in the 19th century,
Yes.
aren't they?
Yes, they were.
So probably 18th century
Yes.
would be safe.
Would it be right to say that in the past, in fact, marrying out of Judaism was probably rather rare for Jewish daughters, and therefore the possibility that quite a large range of the population actually has some female Jewish antecedent is rather less than it might be if one
Your
were
Lordship
living in...
may well be right. There's no material, certainly no material that's before the court, there's no material I'm aware of that provides any figures on that, but one may well be able to make such an assumption given the greater insularity of communities that were likely to be the case in times past, that people lived in their community, they were less likely to marry outside that community. But I have no material that could support that. So the position is that M is refused the place at the school, is refused priority. The letter, and I don't invite the court to go to it, if the court wants to see the letter, it's Appendix Part 1, page 198. There's a fuller correspondence, again, not necessary to turn it up. Appendix Part 3, pages 1146 to 1151. There's an appeal by E to the appeal panel, which is an independent body which dismissed the appeal. Appendix Part 1, page 218. Again, no need to read it. There was an objection made to the school's adjudicator, who rejected the challenge to the oversubscription criteria. Appendix Part 1, page 279, at paragraphs 13 to 14. Now, there are a number of important background matters that I should just mention in this context, and your Lordships and Ladyship already asked some questions about this. First, the parties agree, as I understand it, that for the purposes, and I emphasise for the purposes, of orthodox religious law, it is most definitely for the Chief Rabbi to determine who is a Jew. He accepts that at paragraph 23 of his printed case. And my Lord Lord Hope asked me about that a few moments ago. And it is, of course, very well established that the courts will not seek to intervene in relation to matters of religious law, questions of internal assessment of by a religious authority. If one needs it, we've cited authority at paragraph 29 of our printed case. One of the authorities there is a judgment of my Lord Lord Brown in the Waffen case against the Chief Rabbi in 1992, but I won't labour that point.
Just in passing, can I mention that there was a case before the House of Lords from Scotland called Percy, I don't know whether you know about that, which covered the same ground, although it was dealing with a contract.
Your Lordship, of course, is grateful for that. We should have referred to that case as well. Thank you, my Lord. The second matter not in dispute is that whether a person is Jewish according to Orthodox Jewish law depends on establishing that the person was either born to a Jewish mother or that the person has undergone a valid Orthodox conversion to Judaism. And there's evidence on this. There's a lot of evidence, but can I confine myself to the statement of Mr. Fry, who's the registrar of the London Beth Din, that's the religious court of the Chief Rabbi, at Appendix Part 2, page 543. Mr. Fry, the registrar, at 543 of Appendix Part 2, describes over the page at 544, paragraph 4, that in the United Synagogue, as in any other body under Orthodox Jewish law, the criterion of Jewish identity is that the person concerned is either born to a Jewish mother or has undergone a valid Orthodox conversion to Judaism, these rules are universally accepted within Jewish orthodoxy, and they have been for millennia. And then paragraph 5 deals with the practicalities, the usual means of showing Jewish status, and I emphasise it is a matter of status, not a question of belief, not a question of practice, is by producing evidence that the person's parents or maternal grandparents were married in an Orthodox Jewish wedding ceremony. This provides good evidence of Jewish status because permission to marry in an Orthodox ceremony is only granted if the couple are Jewish. Sometimes one may have to go back several generations in order to find antecedents through the maternal line who have married in an Orthodox ceremony. When such evidence is unavailable, other documentary evidence may be accepted. In the absence of documentary evidence, oral evidence may also be accepted. So that's the general rule. There's a bit more detail at paragraph 9 on page 545. Attendance at the services of a synagogue has no bearing on a person's Jewish status as a matter of Jewish religious law. Being Jewish is a matter of religious status under Jewish religious law. And Mr. Fry then exhibits a note at 546 which cites a very old precedent, 548, paragraph 3.2.1. The old precedent is Deuteronomy chapter 7, verse 4. That's the religious origin of this principle.
Lord Pang, do I understand that although the registrar describes these as rules and so on, he regards them as bits of Jewish law which are unchangeable?
Yes. For millennia, he says.
Yes.
These are the fundamental doctrines of Orthodox Judaism.
They're the fundamental laws of Orthodox Judaism.
Fundamental laws. They are the basic laws of Judaism.
That's his belief.
There is the special case of adoption as well, isn't there? Which the forms that the schools send out covers that as well, but it doesn't indicate how it's dealt with.
Well, the position in relation to adoption is this, that the child that's born to a Jewish mother, even if the child is later adopted by someone else, is a Jewish child for these purposes. But assume that the child is adopted by a couple who are Jewish, according to the Chief Rabbi, and the child would not otherwise be Jewish. The position is that if the child is over the age of 13, for a boy, that's the age of a bar mitzvah, then it's a girl who's over the age of 12, that's a bat mitzvah, then that person must undergo an adult conversion process in their own right, because they're old enough to make up their own mind, so they must convert.
And under 13?
Under 13, if the child is under 13 if a boy, under 12 if a girl, then the test is whether the parents themselves, being recognised as Jewish, undertake to bring the child up in an Orthodox Jewish environment. That is the test. And as the process occurs before the child is able to accept commandments for himself or herself, then it can be repudiated, I'm instructed, by the child on reaching adulthood, which is 13 for the boy.
If a Jewish married couple wish to adopt, they have to go through a process under the English law and Jewish law as well, do they?
Yes, this would all be additional to English law requirements.
Yeah,
yes.
obviously.
Yes.
Okay.
There would be Jewish law requirements specifically directed in relation to a child under the age of maturity, as recognised by Judaism, whether or not the child is being brought up in an Orthodox Jewish environment. That is the rules in relation to adopted children.
Lord Panic, one might jump to the conclusion that the underlying reason for according Jewish status to dependent upon the mother, not the father, is that one can be more certain of one's mother than of one's father.
Yes.
In fact, that doesn't appear to be the underlying rationale if you look at page 550.
No.
It's that if you marry a Gentile, the Gentile may interfere with your religious practice and persuade you perhaps to worship some other god.
Well, that's the religious basis in Deuteronomy. I mean, the suggestion your lordship puts to me has, of course, the virtues of rationality.
Yes.
But I hope I may say, without offending anybody, that we are here concerned with religious laws, which, of course, are not laws that this court or anyone else will wish to subject to an assessment as to their objectivity. They are the fundamental laws. That's what is believed. But I take your lordship's point.
Could I just be quite clear? Looking at the first two words on page 548, when the phrase Jewish law is used, is that universal Jewish law or is it Orthodox?
Well, I'm coming to that. There is no dispute that all branches, if I may use an inappropriate word, of Judaism, that is Orthodox, Masorti, Reform and Liberal, they all proceed on the basis that whether you are Jewish does not depend on your beliefs and it does not depend upon your practice. They all believe that it is a status that is conferred by descent. There are differences, however, because the liberals believe that descent may be or is relevant whether it's from the father or the mother. The Masorti and the Reform and the Orthodox all base their basic religious laws on descent from the mother. That's the first difference. The liberals include descent from the father. The second difference, of course, is that non-Orthodox communities are more flexible, if I may use that word, in relation to the procedures that they apply in relation to conversion. And that's why M is regarded as Jewish for religious purposes by the Masorti, by the Reform and the Liberals. But they all apply a test of descent and not a test of practice or belief. And the evidence on this, can I take it very briefly because your lordship asked me about it and it is important, is Appendix Part 3. If the court would go, please, to page 1035.
But just before we move away from the statement, the answer to my Lord's question, what is meant by Jewish law, the top of page 548,
yes,
is Jewish Orthodox law.
Oh, certainly. Undoubtedly so. Mr. Fry is only talking about Jewish Orthodox law. However, the answer to the question from my Lord Hope is that very similar principles are applied by the other branches of Judaism. The distinctions, as I say, are that the liberals recognise patrilineal descent as well as matrilineal, and the non-Orthodox communities are more flexible in who they will recognise as converting into Judaism. Now, the Reform synagogues, the Treasury Solicitor very helpfully wrote to all the branches, and the letter that was written appears at 1031, and I won't take time on that. The answer from the Reform community...
We're in part 3.
It's part 3, yes, Appendix Part 3. Page 1035 is the answer from Rabbi Dr. Tony Bayfield. You see this at 1038, who's the head of the movement for Reform Judaism. At 1035, under background information, he says in the second paragraph, This definition, that's the OCR definition, is in essence shared by the entire Jewish world, both in Britain and globally. There are nuances, the most significant of which is that the liberal movement regards as Jewish a child either of whose parents is Jewish. However, all Jewish institutions worldwide, as far as he knows, say that Jewish identity is determined by either dissent or conversion. So it's not a question for liberals of belief or of practice. And over the page, top of 1036, the OCR's definition of Jewish status is, in its essence, universal, dissent or conversion. This is significantly different from the Christian definition of a Christian, which is much more heavily focused on creed and religious observance. And leaving out a couple of lines, it won't work for Judaism. It goes against the historic Jewish definition of a Jew, and, he says, would be a flagrant infringement of the right of a religious group to define itself. Leaving out two paragraphs, when it comes to matters of Jewish status, we, that's the Reform movement, are more liberal than the Orthodox, more inclusivist. This applies particularly in the area of conversion, where we're keen to count in as many people who wish to define themselves as Jews as possible. We follow the maternal line. Our formal requirements for conversion are almost exactly the same as those of Orthodoxy, but we are less exacting and more pluralistic. However, in the last analysis, the issues between us, that's Reform and Orthodoxy, have far more, he says, to deal with who is a rabbi than who is a Jew. They're about rabbinic authority, about an establishment, that's the Orthodox community, in conflict with a non-conformist group. And at the top of 1037, his view, Rabbi Bayfield of the Reform movement, this is an internal matter for the Jewish community. We would not want the law of the land to question the right of the Chief Rabbi to define Jewish identity the way that he does, and they respectfully don't think it wise or right for the state to get involved. This has nothing to do with race or racism, and we respectfully agree with him. So that's the Reform movement.
Yeah. Lord Canning, if the Jewish status were determined according to the Orthodox Jewish religion simply on the basis of dissent, without the alternative of conversion, would your argument be precisely the same in this case? I thought it would.
Absolutely so, and I'll explain if I'm out developing it in a moment. The answer is yes. The Masorti community, just to finish this point, the Masorti community apply the same general criteria of dissent through the maternal line or conversion. The letter is at page 1019, letter from the Assembly of Masorti Synagogues, from their executive director. He confirms the criteria for membership of a Masorti synagogue are an individual must be Jewish. The definition for Jewish is in effect the same as that of the office of the Chief Rabbi, except we defer to our Bet Din, that's their religious courts. Thus, a child is judged as Jewish if they can demonstrate they're of Jewish descent in the maternal line, or their mothers can satisfy the Masorti Bet Din they completed a course of conversion before the birth of the child, or the child has themselves been converted in accordance with the standards of the Masorti community.
And M's mother did.
Yes, precisely so. That's why M is recognised as Jewish by the Masorti synagogues and by the Reform and by the Liberals. The Liberals, their criteria are at 1014, and I won't read it all, but in the fourth paragraph, the court will see that liberal Judaism affirms the absolute equality of men and women, so a Jewish father is equivalent for status purposes to a Jewish mother. That's the difference between the liberals and the Reform, Masorti, and Orthodoxy. Now, all of
what
this
page
is
was that?
page 1014, Lord. And I was referring the court to the fourth paragraph. Now, this is all very important for this reason. If the principles stated by the Court of Appeal are correct as a matter of law, then it is unlawful race discrimination for a school to adopt over-subscription criteria that follow the principles either of Orthodox Judaism or the Masorti community or the Reform or the Liberal. There's no distinction by reference to the test stated by the Court of Appeal in this case. It's not orthodoxy against the others. They would all be acting unlawfully. Conversions, may I just mention this. Mr. Fry, in the note to which I drew attention, which was Appendix Part 2, page 548, summarises the position at the bottom of Appendix Part 2, page 548, where he says that Judaism does not actively seek converts. This is the bottom of 548. And elsewhere in the materials, there's an explanation why that is so. It's because Judaism is a non-proselytizing faith. It does not actively seek converts because Judaism does not teach that you have to be Jewish in order to have a share in heaven. But Judaism has a long history, says Mr. Fry, spanning millennia of accepting converts. Once accepted, they become fully fledged members of the Jewish people, no limit on the number, no restriction based on the ethnic or religious origin of the convert. And there's some historical examples of persons very important to Judaism who either were themselves converts or of convert descent. Again, there are distinctions between orthodoxy and the other branches of Judaism as to the standards that are applied, religious standards, before a person is held to have satisfied the demands for conversion. Mr. Fry summarises the position at 4.3 on page 549 as to what is required of a convert by orthodoxy. And I won't read them out, but they are there set out. Now, there's no dispute in this case that M is not Jewish according to Orthodox Jewish religious principles as recognised by the Chief Rabbi. There's no dispute about that. Diane Gelly deals with this in his witness statement for the United Synagogue. Diane Gelly is Appendix Part 2, page 590. He's the senior senior judge of the London Beth Din, that's the religious court, at page 590, and he deals with this point at 596 at paragraph 25. Diane Gelly tells us the case of the claimant's son provides a straightforward application of the principles set out above relating to Jewish status. The claimant is Jewish, that's the father. His former wife was not born Jewish. She underwent a conversion under the auspices of an independent progressive synagogue. Such non-orthodox conversions are not recognised by the London Beth Din. The son has not converted to Orthodox Judaism. Accordingly, the son is not Jewish, applying the principle of matrilineal descent. The position is sufficiently plain that he, the father, has not applied to the Beth Din for a determination of his son's status in Orthodox Jewish law. So the position then, summarising all of this, is that the background to this litigation is a religious dispute between different sections of Judaism about the standards to be applied to conversions, and indeed many other subjects. They all recognise that descent is the test of whether you are Jewish, but different standards for conversion, and the ineligibility of M is the consequence of his mother having converted through a non-Orthodox conversion not recognised by the Chief Rabbi.
Well, it's a consequence of that, but one could equally say it's a consequence of the fact that his mother was
Indeed
an Italian and not.
Well, indeed, I'm coming to that. Had the mother converted in an Orthodox ceremony, he wouldn't have the difficulty that he does have. One other background matter, and that's the case of Mr. and Mrs. L, who have presented written submissions to the court. I've spoken to Mr. L. He tells me, I hope this is right, that he's not seeking to maintain anonymity, and that is right, and therefore I can refer to his full name. I didn't want to do it without Mr. Lightman. And Mr. Lightman, his position is that his difficulty is the consequence of the religious principle applied by the Orthodox community, that for a conversion to be valid, the individual must have intended at the moment of conversion to comply with all religious laws. That's the religious principle, and it's set out by Diane Gelly, and I'm not going to take time on this, but Diane Gelly explains this, Appendix Part 2, page 594, paragraphs 20 to 22. Now, the position here is that this appeal is not concerned with the facts of Mr. Lightman's case. It would, with the greatest of respect, not be appropriate for this court to determine the rights and wrongs of religious law as it is applied to Mr. and Mrs. Lightman. And the case of Mr. Lightman is fully addressed by Diane Gelly in Appendix Part 2, pages 597 to 599, paragraphs 31 to 42. And that's all I wanted to say in relation to Mr. and Mrs.
I mean, we've been given, I think, just this morning, a further letter from the Lightman.
Yes, indeed.
I mean, which I think challenges that on the facts. But with the best one in the world, I don't think it can actually make any difference
Well,
to
in
the
my
outcome
submission,
of the appeal.
No, in my submission, this case raises important questions of law. The Lightman's case is a factual application, and no doubt a difficult and distressing one for Mr. and Mrs. Lightman, but it doesn't affect the issues of principle. Now, can I then turn to the complaint of direct race discrimination? And our case is very simple indeed. Our case is that the Court of Appeal erred because M failed to satisfy the oversubscription criteria because, and only because, of the application of a religious test, a test of religious law. And to satisfy that religious test, which is the foundation of the oversubscription criteria, it is neither necessary nor is it sufficient for an applicant, the child or the parent, to show that he or she is of any particular ethnic origin. It is no answer, we will submit, for A, to emphasise correctly that whether M is Jewish depends on whether his mother was Jewish when he was born. This depends entirely on the application of religious law and does not depend on whether the mother has or has not any particular ethnicity, Jewish or otherwise. I use ethnicity in the sense of the Race Relations Act. May I come to the Race Relations Act just to remind the Court of the relevant provisions, which will be very familiar to the Court. They're in volume 9 of the materials at tab 73. And at the first page of tab 73 of volume 9, section 1, racial discrimination. A person discriminates a person discriminates against another in any circumstances relevant for the purposes of any provisions of this Act if A, and this is direct discrimination, on racial grounds, he treats the other less favourably than he treats or would treat other persons. B is indirect, and I'll come to that in due course. 1A is the new version of indirect discrimination, and I'll come on to that later. Section 3, meaning of racial grounds, racial group. 3.1, unless the context otherwise requires, racial grounds means any of the following: colour, race, nationality, or ethnic or national origins. Racial group means a group of persons defined by reference to colour, race, nationality, or ethnic or national origins. References to a person's racial group refer to any racial group into which he falls. And 3.2, the fact that a racial group comprises two or more distinct racial groups does not prevent it from constituting a particular racial group for the purposes of this Act. And 3.4, subsection 4, a comparison of the case of a person of a particular racial group with that of a person not of that group under section 1.1 must be such that the relevant circumstances in the one case are the same or not materially different in the other. And I'll come on to the relevance of that in a few moments. Section 17, which is on page 13, deals with discrimination in the educational field. And section 17 tells us, subsection 1, it is unlawful in relation to an educational establishment falling within column 1 of the following table for a person indicated in column 2, that's the responsible body, to discriminate in the terms of admission or by refusing or deliberately omitting to accept an application for admission. And column 1, educational establishment maintained by the LEA, that's JFS, the responsible body is either the LEA or the governing body, according to which of them has the function. And as the court has seen, admissions is a function of the governing body, so the governing body is responsible. Now, there are two basic principles which have been applied by the courts, including the appellate committee, in the context of direct race discrimination, and which are not in dispute in this appeal. They were summarised by Lord Nichols for the appellate committee in Nagarajan, which is volume 4 of the materials at tab number 39. And the background detail of Nagarajan doesn't matter for this purpose. It's the statement of principle by Lord Nichols. The first point of principle that Lord Nichols stated is at the bottom of 510, page 510, tab 39, in volume 4. At the bottom of page 510, Lord Nichols, who's speaking for the House, said in the final line on 510, thus in every case it is necessary to inquire why the complainant received less favourable treatment. This is the crucial question. Was it on grounds of race, or was it for some other reason? For instance, because the complainant was not so well qualified for the job. Save in obvious cases, answering the crucial question will call for some consideration of the mental processes of the alleged discriminator. Treatment favourable or unfavourable is a consequence which follows from a decision. Direct evidence of a decision to discriminate on racial grounds will seldom be forthcoming. Usually the grounds of the decision will have to be deduced or inferred from the surrounding circumstances. So that's the first question. What was the ground of the decision? And later authority, if I may just pause there, later authority, which is discussed by my Lady Baroness Hale in my Lady's chapter in the book on the Judicial House of Lords. As my Lady points out, the cases distinguish the question on what ground did the defendant act from the motivation question, which I'm coming on to, but it's important to note, as my lady points out, that this first question, on what ground, is itself problematic because it is not an objective question of causation, it's a subjective question of what was in the mind of the defendant, the alleged discriminator. And this point was emphasised by Lord Nichols again for the appellate committee in a later case. Can I invite the court to keep open Nagarajan, but also open, please, volume 2 at tab 16, which is the Chief Constable of West Yorkshire Police and Calm. And Lord Nichols, again speaking for the House, says at paragraph 29 on page 1072, where he's dealing with the question of the ground on which the decision was taken. He's referring back to the third ingredient, which is defined in paragraph 23. But he says it doesn't raise a question of causation, as that expression is usually understood. Causation is a slippery word. Normally it's used to describe a legal exercise. Sometimes the court may look for an operative cause, the effective cause. Sometimes it may apply a but-for approach. For the reasons he sought to explain in Nagarajan, a causation exercise is not required. The phrase is on racial grounds, and by reason that denote a different exercise. Why did the alleged discriminator act as he did? What, consciously or unconsciously, was his reason? Unlike causation, this is a subjective test. Causation is a legal conclusion. The reason why a person acted as he did is a question of fact. And I say here, there's no real doubt, couldn't be any doubt, what is in the mind of JFS. My client has decided to follow the religious advice of the Chief Rabbi. And there's also no doubt what is in the mind of the Chief Rabbi. He's purporting to apply as best he is able the basic laws of Judaism. The question, however, remains, is that approach one that is in substance, as it is put against us, less favourable treatment on grounds of ethnic origins? And I'm going to deal with that in a moment.
Don't we have to divide reason in this paragraph in Lord Nichols' speech into ground and motive? I don't think he's addressing that distinction.
That's the second. I'm grateful to your Lordship. The first question of principle is, what is the ground? What is the ground upon which the decision was taken? But the second
and
fundamental...
the answer to that will be a statement of fact.
Yes, precisely so.
Yes.
But the second point, which is the answer to my Lord Mance's question, is that it's very important, says the case law, to distinguish the ground from the motive. And Lord Nichols deals with this, if we may go back to Nagarajan, at page 511, and pick it up at 511b, where I left off, where Lord Nichols says, and we do not dispute, this is basic discrimination law, the crucial question just mentioned, that's the question on what ground, is to be distinguished sharply from a second and different question. If the discriminator treated the complainant less favourably on racial grounds, why did he do so? The latter question is strictly beside the point when deciding whether an act of racial discrimination occurred. For the purposes of direct discrimination under 11A, as distinct from indirect discrimination under 11B, the reason why the discriminator acted on racial grounds is irrelevant. Racial discrimination is not negatived by the discriminator's motive or intention or reason or purpose. The words are interchangeable in this context, in treating another person less favourably on racial grounds. In particular, if the reason why the alleged discriminator rejected the complainant's job application, or any other context, was racial, it matters not that his intention may have been benign, and he gives some examples. And I emphasise, it is no part of my case to suggest to the court that if, and this is the ground upon which we fight our case, if the court were to conclude against us that the test being applied is a test that is on the ground of race, that is ethnic origins, we can answer that complaint by establishing a benign motive. Our case is that we are not acting on the ground of race or ethnic origins. That is not the basis of the distinction that is drawn. It's not the ground of the distinction.
You say you never get to question 2.
Precisely so. Precisely so. The Court of Appeal thought wrongly, in my respectful submission, that our argument is about motive, but it most definitely is not. So that's the basic principles of discrimination law. There is also no dispute between the parties that for the purposes of the 1976 Act, Jews do form a group who have common ethnic origins so that less favourable treatment of a person because he is Jewish or is thought to be Jewish may, and I emphasise may, I'll explain why in a moment, may amount to direct race discrimination contrary to the Race Relations Act. Now, the reason I say it's common ground that Jews are protected, I'll come on to the extent to which they're protected by the Race Relations Act, is because Mandler and Dow Lee adopts a test of what an ethnic group means for the purposes of the Race Relations Act. And can I invite the court, please, to go to volume 4 of the authorities, Mandler and Dow Lee, which is volume 4, tab number 35. The issue in that case being whether Sikhs were a racial group for the purposes of the 1976 Act. That was the issue in the case. Their Lordship's House answered yes. And Lord Fraser, for the Appellate Committee, speaking for the House, stated the general criteria of an ethnic group for the purposes of the 1976 Act, starting at page 562, just under letter D. And Lord Fraser says, just under letter D on 562, for a group to constitute an ethnic group in the sense of the 1976 Act, it must, in my opinion, regard itself and be regarded by others as a distinct community by virtue of certain characteristics. Some of the characteristics are essential, others are not. One or more of them will commonly be found will help to distinguish the group from the surrounding community. And he gives some, a long shared history of which the group is conscious as distinguishing it from other groups, the memory which it keeps alive. Cultural traditions, including family and social customs, matters often but not necessarily associated with religious observance. Either a common geographical origin or descent from a small number of common ancestors, a common language not necessarily peculiar to the group, a common literature peculiar to the group, a common religion different from that of neighbouring groups or from the general community surrounding it, being a minority or being an oppressed or a dominant group within a larger community, for example, a conquered people, and their conquerors may both be ethnic groups. A group defined by reference to enough of these characteristics would be capable of including converts, for example, persons who marry into the group, and of excluding apostates, provided the person who joins the group feels himself or herself to be a member of it and is accepted by other members, then he is, for the purposes of the Act, a member. And that's consistent with the words at the end of section 3.1. A person's racial group refer to any racial group into which he falls. In my opinion, it is possible for a person to fall into a particular racial group either by birth or by adherence. It makes no difference, so far as the Act is concerned, by which route he finds his way into the group. So those are the general criteria. He then turns to address in particular a case in New Zealand which related to the Jewish community, just under C on 563. He says he's attempted to explain the reasons why, in his opinion, the word ethnic should be construed relatively widely in what was referred to by Mr. Irvin, who was appearing for the complainant, as a broad cultural historical sense. The conclusion at which I've arrived by construction of the Act is greatly strengthened by consideration of the decision of the Court of Appeal of New Zealand in King Ansell. And taking it briefly, at F, the decision of the Court of Appeal was that Jews in New Zealand did form a group with common ethnic origins within the meaning of the Act. And at 564, he cites from Mr. Justice Richardson at B, and then at C, a group is identifiable in terms of its ethnic origins if it's a segment of the population distinguished from others by a sufficient combination of shared customs, beliefs, traditions, characteristics derived from a common or presumed common past, even if not drawn from what in biological terms is a common racial stock. It's that combination which gives them an historically determined social identity in their own eyes, in the eyes of those outside the group. They have a distinct social identity based not simply on group cohesion and solidarity, also on their belief as to their historical antecedents. And Lord Fraser says that last passage sums up, in a way upon which he could not hope to improve, the views he's been endeavouring to express, and he says it's important that courts in English-speaking countries should try to adopt the same approach. And there are also judgments in Australia to the effect that Jews form an ethnic group. It's volume 3, tab 30, Federal Court of Australia, paragraphs 110 to 113, which there is no need to turn up. King Ansell, the New Zealand case, if the court wants to read it, although I don't take time on it, is volume 4, tab 31.
How far do the words regard themselves form an essential part of that definition, bearing in mind that discrimination is to be judged to some extent through the eyes of the mind of the discriminator? I mean, supposing you form a view that the inhabitants of a particular county of England are particularly retrograde, or they wouldn't regard themselves as a separate ethnic group, but wouldn't you be committing an ethnic offence if you started to abuse them?
I would respectfully so submit. If in truth they constitute an ethnic group, yes.
Well, supposing they didn't, I'm supposing you were completely misguided. You sadly formed the view that all Londoners were degraded and in some ways separrit.
Let's have a more plausible example. Yorkshire women.
I'm sorry?
Yorkshire,
Yorkshire,
yes. Well, my lady comes from Yorkshire, so she can afford to say that.
But it is more plausible that Yorkshire people would regard themselves as an ethnic group than that Londoners would.
Well, I was suggesting a situation where, in fact, the group didn't regard itself as an ethnic group, but since discrimination is to be judged from the viewpoint of the discriminator, supposing you have a misguided perception of a particular group as an ethnic group and you abuse them on that basis, aren't you discriminating?
Well, yes, subject to limits. I mean, there must be some limits of rationality. The fact that you regard some group that plainly cannot possibly fall within the criteria set out by Lord Fraser, and you decide you're going to treat them less favourably, you happen to think entirely misguidedly that they form an ethnic group, cannot sensibly amount to race discrimination. I mean, supposing, it's very difficult to think of a good example, supposing that I misguidedly, I've read Mandler and Dowell Lee, and I've read the Race Relations Act, and I think that members of the Liberal Party, Liberal Democratic Party, form an ethnic group, and I decide to treat them less favourably. I mean, the fact that I'm entirely misconceived couldn't possibly, I would suggest, bring one within the Race Relations Act. There must be some limits here. But I take the Lordship's point. The perception of the discriminator is very important, and the case law so establishes. And that's a development since Mandler Lee. While we have that open, could I also indicate, ask your Lordships to note, that at page 562, just under letter B, Lord Fraser notes, well, let's read the whole sentence, just above B. The 1972 meaning is too loose and vague. It's capable of being read as implying any one of the adjectives racial, cultural, religious, or linguistic would be enough to constitute an ethnic group. This cannot be the sense in which ethnic is used in the Act, as that Act is not concerned at all with discrimination on religious grounds. So I draw that to your lordship's and your ladyship's attention. Of course, Parliament has now acted in that respect. Now, the reason why I said, and it's relevant to Lord Fraser's final comment there, the reason why I said that less favourable treatment of a Jew may be on grounds of their ethnic origins, and therefore within the scope of the Race Relations Act, is that it may also be on the grounds of religion. And it's necessary in any case to identify the true ground for the less favourable treatment. And there's a case on that, a judgment of Mr. Justice Slynn, as he then was, in the Employment Appeal Tribunal, Said and Gillette Industries. It's volume 7, my lords, of the authorities, and it's tab number 65. Tab 65 is Said and Gillette Industries Employment Appeal Tribunal, presided over by Mr. Justice Slynn, and the context is that Mr. Said claimed he'd suffered a detriment at work because of anti-Semitism. And the principles are set out by Mr. Justice Slynn at page 7, paragraph 21, where his lordship says this decision of the industrial tribunal, sorry, I'm ahead of your lordship, it's volume 7, tab 65, page 7. Paragraph 21, this decision of the industrial tribunal is attacked on a number of grounds. Firstly, a question which had to be considered by the industrial tribunal was whether they had jurisdiction to deal with the matter at all. The point was quite rightly raised as to whether what had happened here was on the ground of Mr. Said's religion. If it was, then it appeared to be outside the provisions of the Race Relations Act. On the other hand, if it was on the ground of his race or ethnic origin, then it would be within the ambit of the Act. Both sides accept, and the tribunal accepted, that Jewish could mean that one was a member of a race or a particular ethnic origin, as well as being a member of a particular religious faith. The tribunal on that basis found that what happened here was not because Mr. Said was of the Jewish faith, but because he was a member of the Jewish race or of Jewish ethnic origin. And that's a factual finding. It seems to us that their approach to this question was the right approach, as agreed by the parties. They were perfectly entitled to find, on the facts of this case, that the remarks were on the basis of Mr. Said's race or ethnic origin.
But that does raise the question, doesn't it, as to what Mr. Justice Slynn meant by of the Jewish faith. I mean, if you are discriminating against somebody on the ground of their faith, logically you would think you'll be discriminating because of their behaviour or belief on a faith-induced basis, not on something which doesn't affect their attitude or consciousness at all.
Yes. Well, I take your lordship's point, but there is a distinction that's being drawn. In my submission, a distinction that must be correct in principle. It is necessary on the facts of any particular case to identify whether the ground of the less favourable treatment of which complaint is made is a ground that goes to ethnic origin or race, in which case it is within the scope of the Race Relations Act, or whether the true ground, on analysis, of the less favourable treatment is religion.
But are those two things mutually exclusive? Or can it be both?
In my submission, on the facts of this case, it is religion and not...
I see that, but I'm just asking the question in principle.
I know. I can't think of an example where it would be both. I suppose it might be both in the sense that it's sufficient for the purpose of bringing your case within the Race Relations Act to show that a significant or a substantial ground of the less favourable treatment is race. And there may be other grounds which are purely religious, but that wouldn't help you, the defendant, because it's enough for the complainant to show that race or ethnic origins is a significant or a substantial part of the ground. But we say here, and I'm now going to develop the argument, we say here the true ground of the less favourable treatment that has been suffered by M is not his ethnic origins or anybody else's ethnic origins, it is religion. And can I seek to develop that argument, which is the core of this case on direct discrimination? Our case is that we, JFS, apply and only apply the criteria stated by the Chief Rabbi. And the Chief Rabbi is simply not concerned with whether a child has a particular race or a particular ethnic origin. We're only concerned here with ethnic origin. The Chief Rabbi is only concerned, because he's a Chief Rabbi, with religious status. And that he, the Chief Rabbi, is concerned with religion and not ethnic origin, and that the two concepts are fundamentally different, are demonstrated by considering the treatment of two contrasting cases. The first type of case is the one with which we are here concerned. Suppose a family are all of Jewish ethnic origins for the purposes of the 1976 Act. Under Mandler and Lee, there can be no doubt that they are undoubtedly of Jewish ethnic origins, applying Lord Fraser's test. They are active and committed Jews. They're members of a synagogue. They practice the faith. Let us assume they eat only kosher food. The men cover their heads at all times, and they observe all the festivals religiously. Assume also that their social life, their cultural life, is based around their Judaism.
And isn't this quite a good description of the Lightman family?
Indeed. And it's quite a good description if one leaves aside problems of conversion of E&M. But it's one type of case. They base their social, their cultural life around their Judaism, around the Jewish community in northwest London. But, and it's the big but, the mother and the son are simply not Jewish under Orthodox Jewish religious law. And the reason they're not Jewish for religious purposes, I emphasize religious purposes, as defined by the Chief Rabbi, is because of the fact that the mother was not born Jewish and she converted in a ceremony not recognised as being valid by the Chief Rabbi. That family would have no difficulty whatsoever in establishing that they are of Jewish ethnic origins for the purposes of the 1976 Act. The Chief Rabbi is simply not concerned at all with whether this family and all members of it do have Jewish ethnic origins. His only concern is a purely religious concern as to whether, by reference to the basic religious laws of Orthodox Judaism, they are Jews. And applying that narrow religious criterion, they are not Jewish for religious purposes, and therefore they do not qualify under the oversubscription criteria. Their ethnic origins have absolutely nothing whatever to do with the decision. That's the first type of case. There is a contrasting type of case that makes the same point. This is the case of the person who is plainly not, for any purposes, of Jewish ethnic origins under the Mandler and Lee test. Suppose there is a woman who is not Jewish at any time until she decides that she wishes to convert to Judaism in an Orthodox ceremony. She's born and brought up in a family that has no connections with Judaism, but for whatever reason she decides she wishes to convert to Judaism. And assume that she goes through an Orthodox ceremony and she, from that point on, is recognised by the Chief Rabbi for religious purposes. I emphasise for religious purposes. She is then a Jew for Orthodox religious purposes. And suppose that 10 years later she loses interest in Judaism. Assume that she has no further connection with Judaism. That she marries a non-Jewish man. They have children. None of the family has any associations with Judaism, any interest in Judaism. And yet, applying the religious criteria, I emphasize the religious criteria of the Chief Rabbi, she and her children are Jewish. And therefore, if they live in northwest London and they decide that they wish the children to go to JFS because, as it is a first-class school, the children are eligible under the oversubscription criteria. Again, the ethnic origins of the mother and the son are simply irrelevant. They are entirely irrelevant to the question whether the child is eligible, as he or she is, for admission to the school. Again, the ground which distinguishes that child from other children who are not eligible is that applying the particular basic laws of Judaism, that child qualifies for religious and only religious reasons. So we say, and this is the core of our case, there will be many children who satisfy Lord Fraser's test. They have Jewish ethnic origins for the purposes of the 1976 Act, but sadly for them, they do not qualify under the oversubscription criteria because they're not recognised as Jewish for religious purposes of Orthodox Judaism. And there will be some children who lack Jewish ethnic origins under the Act who do qualify for admission to JFS because for religious purposes they are recognised by the Chief Rabbi as being Jewish. And whether you qualify or you don't depends upon the application of a religious test which is not equivalent to a test of a person's ethnic origins. It may be that one then has to look at indirect discrimination, which I'm coming on to, but for present purposes, I'm seeking to respond to the Court of Appeal's finding that this is direct discrimination, that whether a child qualifies or does not qualify depends on their ethnic origins.
Can we take this family that falls into the latter description? You would say
Yes.
that they wouldn't be identified under the Mandler approach as being part
Yes.
of the Jewish ethnic group. The Germans, or or some of them, applying an anti-Semitic policy, say we are going to send to the death chamber anybody whose mother or grandmother was Jewish, regardless of whether they're following the Jewish religion, they are off to the gas chamber. On your analysis, would that be racial discrimination or religious discrimination?
One has to look, as we've seen, into the mind of the discriminator. One has to ask what is the core of the discriminator's approach. And the discriminator in the example that your lordship puts to me is not, I apprehend, a ground that is based on any religious assessment at all. It's based upon a criterion which is designed to treat people less favourably, essentially for racial reasons. But that's very different from the case with which we are here concerned, where the distinction is being drawn purely on a religious ground. But there will be undoubtedly hard cases, I don't wish to dispute, as to where the dividing line arises, which will depend upon the facts.
Well, the ignorant might say to themselves, well, we consider this as part of an ethnic group.
Yes.
But if it was somebody of some sophistication who had studied the Jewish religion and what constitutes Jewish status according to Orthodox Judaism, and was prejudiced against anyone who had Jewish status.
Yes, well, of course, the true answer to your lordship's question is that such conduct is fundamentally abhorrent, whether it's racial or it's religious. It really doesn't matter if one's going to impose such a disadvantage. And therefore, if I may respectfully say so, it isn't an example that tests the issue with which we are here concerned. And the reason why the issue, the division, is crucial in the present context is because Parliament, in its wisdom, as Lord Fraser indicated, did not think that discrimination on religious grounds should be included in 1976. But Parliament has considered that it is appropriate to identify the circumstances in which less favourable treatment on religious grounds is acceptable or unacceptable in 2006. And that's why the division becomes so important. And as I've indicated, once one establishes this less favourable treatment is on the ground of religion, then one's within the 2006 Act, and the exception in Section 50 does apply.
Can I ask a question? As I see the Court of Appeal, they, and you criticise them for this, they equated the religious concept of Jewishness with an ethnic concept. Looking at the Mandler test, and bearing in mind that the question of discrimination is judged, at least in some respects, through the eyes of the discriminator, might it not be said against you that the religious test inevitably involves a self-defining subgroup or sub-ethnic group, because taking the conditions, there's a long shared history, and dissent is a critical part of the religious test. There is a cultural tradition of its own, including family and social customs and manners, often but not necessarily associated with religious observance. Then the other characteristics, certainly a common geographical origin, common language, common literature, common religion, and certainly the minority. So bearing in mind that, as I understand, you can have sub-ethnic groups, may that not be the way the Court of Appeal was thinking? I'd just like you to address that.
Yes, well, again, our case is not to dispute that applying the Mandler and Lee test, one can identify either Jews as a whole or subgroups who are an ethnic group applying the 1976 Act. My point is that the alleged discriminator, who is here the Chief Rabbi, is simply not concerned with the ethnic origins, however you define it, within the scope of the 1976 Act. He is asking himself a very different question. He's asking himself not what is the ethnic origin of particular people. He's asking a question and distinguishing people by reference to the particular basic laws of Judaism, which are not coexistent. They are not coexistent with any ethnic group. That's my point. There are many people who are ethnically Jewish who don't fall within the category of the Chief Rabbi's preferred people who are recognized as Jewish, and there are people who are, on any view, not ethnically Jewish, who do fall within the Chief Rabbi's test. Again, he's simply not interested in their ethnicity. He doesn't ask himself about ethnicity. He doesn't apply. He, the Chief Rabbi, doesn't apply any of the criteria that Lord Fraser applies. He asks himself a very different...
Well, one of the questions he asks himself is what the ethnicity of the mother is.
No, he doesn't.
Doesn't he? Is that not one of the questions he has to ask himself as part of his overall
No, with great
analysis?
respect, Lord, he does not ask himself what was the ethnicity of the mother. He asks himself what was the religion of the mother. Was the mother a Jew according to the principles of Orthodox religious law? And that is the same question in substance as asking whether M satisfies the principles of Orthodox religious law. It's just pushing it back a generation.
He, as the judge, has to ask himself questions of law and questions of fact.
Yes.
The question of law is, what fact will constitute this person a Jew? And having decided what the test of fact is, he then has to look at the particular case and say, what is the material fact that decides whether this person is or is not a Jew, and therefore whether this person can or cannot go to the school? And the fact is an ethnic fact.
Well, my submission is it's not an ethnic fact. It is a fact about the religious status of the mother. Now, the mother may or may not have been ethnically Jewish, applying the criteria in Mandler and Lee. But that's irrelevant. It is completely irrelevant whether the mother was or was not ethnically Jewish. And one demonstrates that by asking the question, what would have happened if the mother had converted to Judaism through the Orthodox community? She would have exactly the same ethnic origins, exactly the same ethnicity, but the religious test would be a different test because the religious principles would be satisfied. Ethnicity.
I wonder if I might just pursue that theme a little.
Yes, ma'am.
Presumably, it is possible within the same sibship for individual siblings to be Orthodox Jews and others not to be Orthodox Jews. And take, for example, a mother who had not converted to Judaism and gives birth to a son, then converts to Judaism, complies with all of the requirements. Yes. Her next son born will be an Orthodox Jew.
Your Lordship's correct.
If the first son is refused admission to JFS and the second son is admitted, your argument is plainly that's a decision based on religion rather than ethnicity.
I'm grateful to your Lordship. One could give other examples. If one of the children converts, then Judaism would be established. Lordship's absolutely right. None of this has any is not based upon assessments by the Chief Rabbi, who is the determining authority of ethnicity. And it is simply wrong, in my submission, to suggest that it is the ethnicity of the mother, in this case, that matters. If the mother, as I've said, was born and brought up in northwest London with the most manifest and obvious Jewish ethnicity, M would still not qualify under the criteria stated by the Chief Rabbi if the mother's grandmother had converted to Judaism in a Masorti ceremony. The religious test would not be satisfied. It is not a test that is based either on the ethnicity of the child, and I've shown your lordships, M personally has the strongest of claims to Jewish ethnicity, and it's not based on the ethnicity of the mother. It is a dispute, in my submission, about religious law, which is demonstrated by the fact that M would be regarded as Jewish in the religious sense by a school whose oversubscription criteria applied the religious principles of the Reform movement, Masorti, or liberal Judaism. They would all be very happy to accept him. A school that saw the Masorti community as the religious authority for the oversubscription purposes would admit M. And the only difference between such a school and JFS is that JFS recognises the Chief Rabbi as the religious authority for these purposes. It is a religious test and only a religious distinction which matters in this context. Now, the arguments that I've sought to advance were essentially those which found favour with Mr. Justice Mumby in the Administrative Court. I won't take the court through it, but I invite in due course the court's consideration of Mr. Justice Mumby's judgment at paragraphs 168 to 171 and 173 to 174. I can't remember why I didn't include 172. There must be some reason, but 168 through to 174. And essentially, he accepted this argument. The Court of Appeal reached a different conclusion, and its reasons in our respectful submission were bad in law, as we have sought to explain in our printed case, which I'm not going to take time, and I don't have time to go through, paragraphs 49 to 56 of our printed case. And I invite the court's attention to that in due course, if it hasn't, as I'm sure it has been read already. What I wish to do, if I may, is to identify what we see as four main points which are made by E in his printed case on direct discrimination, which I want briefly to address. And some of the points have been indicated already in questions, very helpful questions from the court. Now, the first point that is emphasised by E is that JFS and the Chief Rabbi are applying a test which depends on dissent. They emphasise that the test of the Chief Rabbi is whether the mother is or was Jewish. And the same point is emphasised by the Equality and Human Rights Commission. Could I invite the court's attention to their printed case just for a moment to see how they put it at paragraph 3 of the case for the Equality and Human Rights Commission. It's
second intervener.
I'm sorry, Lord?
Second intervener.
Yes,
in our bundle.
I hope it's included in the materials that have been slotted into the core volume. I was simply going to ask the court, please, to look at paragraph 3 of their printed case. They tell us the Commission considers that all rules, I emphasise all rules, based on a person's descent from a particular class of person are properly considered to be racial rules. That's the way it is put. And there's some development of that. Now, I want to submit to this court that that is self-evidently too broad a proposition, cannot sensibly be correct. To confer a benefit or impose a detriment on a person by reason of descent, that is, who their father or their mother is or was, may or may not be racial in nature. It all depends. To give some obvious example, it was a rule applied by the print workers' union SOGAT for many years that jobs in the print industry would be handed down to sons. It's normally sons and not daughters, but to sons or nephews. Now, that was objectionable on any number of grounds, but it was not a racial criterion. No one could seriously suggest it was a racial criterion. One can give many other examples. Until 1999, hereditary peers enjoyed membership of the House of Lords. Again, much to be said against it, but racist because based on descent, in our submission, surely not. One could give many other examples. Prince Charles will, in the fullness of time, become our monarch, simply because of who his mother is. But it cannot be the case that this is race discrimination.
Just to take your second example a moment ago, where you took persons, a convert who was a Jew, but then lost interest and married a non-Jew and had a child, wouldn't discrimination on the grounds, supposing you discriminated against or in favour of someone on the ground if they had a mother or grandmother or great-grandmother who at some stage during that woman's life was an Orthodox Jew. Wouldn't that be discrimination on an ethnic ground? I mean, at the time they were an Orthodox Jew, they were a member of ethnically of the Jewish community, you accept. Wouldn't you be adopting a test which then axiomatically, within the Act, was on a racial ground, since it was on the ground of an ethnic origin?
Well, what your lordship's envisaging, there's a school which is quite happy to admit anyone, but not those who have a grandmother who was Jewish, something of that sort.
Yes, that's right.
That type of example. But the answer I would give to your lordship is that it's very difficult to see in that type of case that the ground, applying Lord Nicholl's approach, the ground of the less favourable treatment were truly a religious ground. Why on earth would the alleged discriminator in the real world be distinguishing such people other than for racial reasons? Very different, in my submission, from this type of case, where there can be no doubt, whatever else one might think, that the Chief Rabbi is not involved in some form of sham. I mean, he's concerned with the application only of religious laws. So the examples I give to your lordships and your ladyship as to dissent as a criterion really cannot answer the question that the court has to answer. Dissent of itself is, to use dissent as a criterion, is not of itself to apply a test that is based on ethnicity or race for the purposes of the Race Relations Act. And taking this point further...
Well, why would it not at least be a pointer, even if one doesn't go so far as paragraph 3 of that case?
It's not much of a pointer to say if I'm not going to be the monarch when the end of Her Majesty's reign occurs. I bring my claim for race discrimination and I say that it's race discrimination against me because my mother was not the Queen. It's not much of a pointer to say, in my respectful submission, to say that Prince Charles becomes the monarch by reason of who his mother was. It's no pointer at all. It doesn't take one any further forward.
But that is to exclude the concept of being descended from somebody who's a member of an ethnic group.
Yes. Well, then one has to go. I'm simply at the first point. Is dissent can't of itself, and the Commission seemed to suggest that of itself.
Well, to be fair to them, Lord Penny, they do say descent from a particular class of person. So it's not. They're not talking about, take the royal example, somebody's mother just per se.
But what does a class mean?
Well,
a class of members of SOGAT, or a class of people who were hereditary peers? I mean, they are.
I think, to be fair to them, I think they're taking
Very
a
well.
more.
Well, then
more targeted type of class, really.
Very well. Then one has to identify what it is that is the basis of the complaint here. And in the present case, he deals with the matter in his printed case at page 6. If I could invite the court's attention, please, to page 6 at 19, paragraph 19I, bottom of page 6. He puts it like this: a child with precisely the same religious belief and practice as M, Zorti Jewish, but different ethnic origins of Jewish rather than Italian matrilineal descent would be admitted to the school. So there's the focus on the origins. If the origins were Jewish rather than Italian matrilineal descent, then the child would be admitted to the school. But that, in my submission, simply illustrates the error in the analysis by the respondent and indeed the analysis by the Court of Appeal. As I've said, the Chief Rabbi is not concerned with the ethnic origins of M's mother, whether they're Italian or they're Jewish or anything else. The Chief Rabbi is concerned only with the religious status of M's mother. If she had been brought up not in Rome or elsewhere in Italy, but in northwest London, in a family practicing Judaism, with all the other signs of Jewish ethnic origins, M would still not be eligible for a place at JFS unless the mother was, as a matter of religious law, Jewish. And to focus on descent as the issue simply pushes the same question back a generation or 2 generations. A child is eligible under the oversubscription criteria not because of the ethnic origins of either the child or the mother, but because of the religious status of the mother, which is not the same as her ethnicity for the purposes of the 1976 Act, for all the reasons that I've given.
What about the next sentence? See, the contrast is drawn in this paragraph between the sentence you've looked at and then the school does not give priority to children whose families are members of the Orthodox religion, and examples are given.
Yes. Well, because the religious laws that the Chief Rabbi applies are not concerned with belief. They are concerned with whether, as a matter of Jewish religious law, irrespective of ethnicity, the child is or is not Jewish.
So practice or belief are not the test, it's membership.
Practice or belief are not indicia of whether a person is Jewish for the purposes of Jewish religious law, as your Lordship saw in the witness statement of Mr. Fry. Whether you are Jewish for religious, Orthodox religious purposes depends only on whether for Jewish religious purposes your mother was Jewish and your practice, your belief are simply irrelevant. And I'm coming on to deal with the implications of that.
As I understand it, I mean, you've said several times that there are distinctions between Mandler ethnicity and Orthodox Jewish view of Judaism or Jewish status. But I think paragraph 47 of your case says that even if they were the same, that wouldn't matter because religion is a materially different circumstance. Am I right about that?
Yes, paragraph 47 is seeking to put the same argument by reference to section 3.4 of the 1976 Act. It's not seeking to develop, I apprehend, a different
Well, I wondered about that. It struck me that you only get to section 3.4 if you've identified a discrimination on an ethnic basis, don't you? And then you
With
ask...
respect, no, because the case law suggests that these questions are not to be dissociated one from the other. The question of the ground on which the decision was taken cannot be dissociated from the question of whether it's less favourable treatment. And may I show the court an authority to that effect at 2 o'clock? Thank you. Yeah, all right, all right. I'm within my assessment. Yeah, I'm not going to...